thank you very much for this introduction, and thank you so much for allowing us to be this part of this really esteemed panel. So welcome all of you firstly, and I won't go into introductions because we've already done that. We'll straight away hit at the session because we're already behind schedule. So we are now today discussing about arbitration, mediation and online mediation, and what are the pros and cons that goes around these three alternate dispute resolutions. And of course, as lawyers, we all understand that including litigation and these three aspects, there are a number of pros and cons that we see every day, while we are dealing with the matters, right? So understanding about arbitration first, I'll go to Mr. Sen to begin with. Mr. Sen, we have experienced, I'm sure you also must have experienced that sometimes people or companies, especially individuals, do not prefer arbitration as a mechanism to resolve disputes. Do you think, and also somewhere when we go through an arbitration proceeding, it results into an even lengthier process. So do you think that the purpose of an arbitration proceeding is actually defeated?
Thanks, Petal. So essentially arbitration was meant to be the silver bullet which will be the panacea of all woes of litigation. And that was the original intent, right? And so whichever were the advantages, in effect has become, in a way you could say, a disadvantage as well. So for example, first it was meant to be a fast procedure, or rather faster procedure. Certainly it is not. It's become quite a lengthy proceeding in itself, and this is despite the statutory correction that was made a few years earlier, simply because of the point you mentioned, is that it has just become a pre-litigation proceeding. Because the other advantage of arbitration was it was final and binding. As practitioners, we all see that it's certainly not final. All our clients, invariably, the moment the award comes, whether if you are winning, if you have won the matter, you file the caveat. If you have lost the award, you file the challenge. That's the simple, the simple standard operating procedure. So therefore, the challenge mechanism is also a lengthy procedure. You have all the way to the Supreme Court. It's usually again a three-tier process. So, so the benefits of arbitration as a fast procedure is certainly not there. Cost-wise, again, it's a very expensive mechanism. And as you said, individuals, I don't think individuals prefer arbitration at all. For individuals, mediation would certainly make sense. Business disputes, usually arbitration is the main step, the main redressal mechanism, simply because the courts can take even longer.
Right.
So that's my take on it.
So I think more particularly, we do see that the purpose of arbitration is somewhere being defeated, right, in some way or the other. So, Ms. Bharti, I'd like to understand when we talk about arbitration, of course, like Mr. Sen also mentioned. Welcome, Mr. Chandhiok. So, Mr. Sen also mentioned that mediation, of course, is something which individuals, as well as I think many companies also really prefer. How do you feel that online mediation, especially now with the tech being so prominent, how is that going to be a game changer going forward?
So why only online mediation? I think if we are talking about the online version of the dispute resolution, that is called the ODR, I think it is an idea whose time has definitely come. And COVID has accelerated the entire process. After COVID, we have seen there to be a surge in terms of e-ADR also happening. We have also seen e-mediation happening. And there are various reasons, why it has now taken prominence. I remember in 2013 or 2014, I had spoken in one of such conferences about ODR. And since then, I have seen there to be a huge kind of a revolution in that sense. From 2015 onwards, there are organizations who have been set up in this regard. And they are doing a brilliant job. Sama and all has come since 2015. And, the only reason why e-mediation or online mediation has not become as successful as it should be was because there was a lack of awareness. When we start talking about it in these conferences, I think the awareness will also come, and that will also add on to the success of these processes. And so far as the online mediation is concerned, just look at the advantages that it carries. You can do mediation from wherever you're sitting. You don't have to come to the place and do the mediation. That in itself is a huge kind of a challenge. I mean, Karan is coming directly from the airport. He could have attended the session from wherever he was. That kind of availability of the whole idea is something which is a game changer. Then the cost aspect of it, because if you are traveling, commuting, those kind of issues are also going to make a lot of difference. So why only online mediation? I mean, for online dispute resolution also, I think it is going to be a game changer so far as the cost is concerned. Time also, because you are able to attend to these hearings wherever you are sitting. I think in terms of timeliness also, you are able to save a lot of time. So I think this is definitely is a development in the right direction, and after, I'm sure Karan is going to talk about it a little bit more, but then after the Singapore Convention that India has ratified, the mediation agreements have also now, or the settlement agreements have also now, can be enforced. So that is something which is, paving the way for mediation, and online dispute resolution is the way forward in that direction. And if you look at the history of ODR in that sense, I think from 2006 onwards, when NIXI had come the first time, when the domain disputes could be decided in that sense, I think that was the genesis of the online dispute resolution. And since then, if you look at globally the kind of trends that is there, most of the consumer disputes are now being shifted to online mechanism. So if the world can actually do it, India can definitely do it. And I think there are amendments which are also being brought in so far as the e-commerce regulations are concerned, the Consumer Act is concerned, to include the process of online mediation or online dispute resolution in that sense. So consumer disputes can definitely be taken up in that sense. I also feel that IP disputes can also be taken up through online dispute resolution mechanism, because IP disputes also are not a very complicated set of facts and law. So for those kind of matters which are not very complicated in terms of set of facts and law, those are the kind of matters which can definitely be taken up through online dispute resolution. Then there are section 138. I mean, our courts are clogged with the amount of matters which are pending at the moment before the metropolitan magistrates. So I think if we are able to take those 138 matters which are not very disputed, the ones which have a straight set of, you can identify the signature, you can identify the person who has signed, then you do not really need to clog the courts of India. You can actually shift all of those through ODR mechanisms. E-Lok Adalats have become very, very common. So I think it is an idea definitely whose time has come and has evolved.
And I think with the Chief Justice really emphasizing on online proceedings and having hybrid mode of proceedings, I think it's very important that the infrastructure also should be such that all the lower courts and all the other authorities are able to actually do
so
this.
That I think is the only reason why it has not picked up so well. One is of course the lack of awareness, and second is because there is a lack of digital infrastructure that is required.
Yes.
Although I think the government has done some bit of it by having those common service centers,
absolutely,
which are at least taking the internet now available to the villages also of our country. And with smartphones, I think most people now have the entire this thing in our hand. But awareness is something which still needs to be created. So once we have the digital literacy and we have the digital infrastructure, I think ODR will definitely pick up.
Right. So Mr. Malik, just to, yes.
In fact, the Chief Justice has specifically asked these senior counsels, most of them, that you will only use your iPads and no paper would be allowed for the purpose of argument. Yes, paperless arguments. So that is a step towards it.
Absolutely.
In fact, just to add value to it, to add that much of credence to mediation in the country, this new mediation bill which was introduced in 2021 rather, the standing committee report has come on that. The problem with mediation that existed was always this, that how do you enforce those settlement agreements? Now those settlement agreements, unless those are coming out of as a certificate or as an incorporation into a judgment or a decree or into an award under section 30, they are not enforceable. So the problem that existed in mediation, I think and I hope, will soon get resolved because of that.
I think the Singapore Convention, that issue has also been taken care of to that extent. Now
to
it
that
can
extent.
be enforced as a decree.
It has, but
I think to that extent, but it needs a local enactment to that effect.
I think the only issue will be implementation, how fast we are able to implement, because we also face the issue of, at the end of the day, the agreements that we are executing, they are not enforceable. So somewhere I think the time for implementation is something that we have to wait for.
So the bill which is proposed, the act which is proposed, makes a specific provision to the effect that mediation settlement agreement, they'll be equivalent to a judgment or a decree.
Correct.
Like a settlement agreement arrived in the conciliation proceedings under section 74 of the Arbitration Act.
Which is very important, because otherwise we will have to again go back into a litigation claiming that, this has not been complied with. Nonetheless, so Mr. Malik, going forward and understanding from you, what are the very important ingredients and aspects that we should bear in mind while we are drafting let's say a dispute resolution arbitration clause? What are those aspects that we should actually bear in mind while doing that?
So I think the most important aspect that we always tend to forget is that we need to keep drafting very simple, and particularly the arbitration clauses. What I have seen, and those are very convoluted arbitration clauses where you can't really understand what is the intent of the person who has drafted it. If you are talking about an arbitration, it has to be either you are talking about an institutional arbitration, then adopt the arbitration clause that exists in their rules. Otherwise, rather being innovative creates a problem. As my friend just pointed out, the problem is that once you initiate arbitration proceedings, then what happens? 34 is there, then thereafter appeal is there, then SLP is there. So the entire process becomes convoluted. And the problem is that if your arbitration clause is not drafted properly, you are stuck at the constitution itself, the first step itself. So you need to understand what you want to do. You want an institutional arbitration, you want an ad hoc arbitration, you want particular rules to govern it, you don't want them. But don't confuse that you have an ad hoc arbitration, but you still want certain rules to apply. You are mixing the two things. You are placing jurisdiction somewhere else, you are placing the law somewhere else. All of these creates problems. All of these creates problems, and they all lead to fantastic judgments that the Supreme Court has delivered on these issues. Absolutely. It is good for us, but not for the clients.
Right.
In fact, I feel just to add and supplement to what Mr. Malik mentioned, the problem is that these are considered as those boilerplate clauses.
They are.
We don't have to apply our minds to this. This
Exactly.
is something which is like right there. You have to just cut, copy, paste.
Right.
Unfortunately, the case be. But the problem then arises, and we dispute lawyers are very happy with that. Mind you.
Yeah, of course.
We love these clauses because that's where the interpretation and the dispute sets in, and they come to us.
Right.
But I feel personally you need to spend time on these clauses. Like Mr. Malik mentioned, you need to understand what is the kind of contract, right? Number two, would you want to, layer it up? Would you want it to be a multi-tier dispute resolution clause? Would you also want to, like he mentioned, the seat venue? You'll have to be absolutely clear and unambiguous when drafting your arbitration clause. Additionally, what people don't spend time on is the arbitrability aspect. You would also want to maybe spend time on certain disputes going to, let's say, an arbitration, certain disputes wanting to be referred to court. We don't spend that kind of time on, clauses such as this. If we do that, I think, and get into a little bit of more specifics, it can really add value.
Help us into avoiding
And
most definitely.
Yeah, and a very quick point to add there is, especially for international arbitration, foreign-seated arbitration, Singapore-seated arbitrations, for shareholder disputes after the Anupam Mittal judgment, it's very important that please specify that your law of the arbitration agreement also should be specified to be Indian law. Right. Otherwise, you are running into a complete quicksand there. Yeah.
Right. So Radhika,
No, actually, my only point, especially on arbitration clauses, is a lot of times, especially when corporate lawyers, and excuse all of those in the room who are, is the fact that the question is, do you want to arbitrate? Right? And or is arbitration the better forum? I mean, for example, the way courts look at India for choice of jurisdiction clauses, exclusive jurisdiction clauses, suppose you have a foreign jurisdiction clause, I'm talking about court jurisdiction, vesting a court elsewhere with jurisdiction. Those are looked very differently rather than when you're looking at an arbitration agreement, which may say there's a seat for arbitration in Singapore. Singapore will reply because there is a more pro-arbitration focus. Whereas when you look at courts, they maybe say, is this forum non-convenience? What rules of private international law will apply, and so on and so forth. So the question is, do you want to arbitrate? Is it beneficial to arbitrate? And to Radhika's point, is it even arbitrable?
Yes.
So those are, and of course the cost.
Very
the
important.
cost involved, and especially whether you want to write whether the schedule applies to the clause or not. So the drafting of the clause has to be very intentional.
Right.
And practically anything less than 10 crores, at least my experience is, I don't think it's worth going to arbitration in
I
India.
agree.
It will not be viable.
Right.
That's a great point. In fact, one of the things which we completely miss out is, when we add 3-member tribunal.
Right. Very costly.
It's, it's when the
They're very
dispute
costly.
happens, that's when you realize, how do we get to a sole arbitrator? Yes. How do we reduce costs?
Most of the clients, in their zeal, I don't know, they think that the arbitration is very fancy and they should actually put that clause somewhere. Some corporate lawyers do that. So they come back and they say, but why do we need 3? Because it is that point they realize that the cost is going to be so high. And then there are other issues which crops in. When the arbitral tribunal is telling you, this is the fee that I want, not of the standing schedule for, you can't say no.
My favorite.
I have seen, to start, before these amendments came, there was a matter they were rising out of Chandhiok. 3 arbitrators spent almost half of the claim on arbitral fee, hotels, etc., etc. Supreme Court, I was appearing for a public utility. I requested the court, please change this tribunal. I want only 1. And then 1 judge was appointed, and he concluded it within next 3 months.
Yes. These are certain handicaps.
This is before the amendments came. It was so difficult then to even to persuade and talk about arbitral fee. It was a non-starter.
Right. So Radhika, just to understand from you, when we talk about drafting of the arbitration clause also, and specifically the seat and the venue, etc., how to tackle with a issue where sometimes the parties are not even, let's say the seat of Delhi has been mentioned in the arbitration clause, and the parties itself are not from, let's say, Delhi, or they don't have offices in Delhi. And the jurisdiction, while let's say at the stage of section 34, how do we determine, and if the pecuniary jurisdiction is of a lower court, how do we determine the jurisdiction at that point in time when we are going for a section 34?
The moment the clause has seat as Delhi courts will, have jurisdiction.
So which district of Delhi will have the jurisdiction?
No, depends on then, the value of the matter.
Right.
So, it depends on the matter concern.
Right. So this is a concern which I think is, so let's understand from a perspective why, because when I also feel when parties are not from a certain jurisdiction, we should avoid having that jurisdiction.
I totally agree. So therefore, spending time on drafting of the clause itself is very important.
Yes.
The basic concepts as to, what is a seat, what is a venue, what is the difference between,
right.
Sometimes you're using these terms interchangeably, though, pretty much the law is settled after BG Soma.
Yes.
But there's still gaps. In fact, I have done a matter very recently, and the DB judgment should be out in that, where the question is, if there is a jurisdictional clause, like courts of so and so will have jurisdiction, right? Let's say it's Gurgaon, right? And your arbitration clause mentions venue, right? Then you know where to go, what to do,
right.
and what will take over, because BG Soma says venue has to be read as seat, right? But then you have a jurisdictional clause, and then it says the contra indicia, So we have single judges, having opined on it divergently,
right.
but we don't have a DB judgment yet as far as Delhi High Court is concerned. And let's see what will Justice Sanjeev Sachdeva do.
This
so
is
Mr.
one of
Chandhok,
those examples of convoluted arbitration clauses.
Right, exactly.
And as you rightly asked that question, and it is very pertinent.
Yes.
As to what happens, she rightly said that wherever is the seat, venue has to be read as seat.
Right.
So you specify that, the problem is solved. But the problem is that when you have non-exclusive jurisdiction clauses in the arbitration agreement, what do you do?
Right.
Because Section 2 of the Arbitration Act says that then the jurisdiction will be decided as if it was a civil suit.
Civil suit, right.
And then what happens is Section 42 kicks in,
Absolutely.
which would say that wherever you first invoke the jurisdiction of whichever court, that court will have jurisdiction for all purposes, Section 9, Section 11, then section 34 and later
Absolutely.
whatever proceedings.
Absolutely.
So that's how the jurisdictional part is taken care of.
Right, right. So, Mr. Chandhok, just to also understand, when we talk about dispute resolution in terms of arbitration, do you feel that mediation should also be one of the prerequisites? Of course, we know in the commercial courts that it is a prerequisite that we have to. But do you feel that while we draft an arbitration clause, let's say in a contract, should mediation actually be a prerequisite before arbitration is even invoked? And how effective is that?
Okay, sorry, before I answer that, first let me apologize for being late. I asked for a Passover, but this is an ADR panel, so speed is important. So this, so coming to your question, I think mediation is always a great process because it helps restore relationships. And of course, if you're getting into a contractual relationship with an opposite party, a counterparty, you want to be able to preserve that relationship before it goes to dispute. I don't think so anybody goes into a contract thinking that that I'm here to dispute it later. That's a backup option. So from that perspective, yes, and therefore it has to be, if it's written in the contract, parties agree to it, yes, certainly it should be. Now, whether or not it is mandatory, there is various views on it, especially under the earlier drafting of the mediation bill, which did make it mandatory, but left, it was sort of the section was lawyer's paradise. It said, it has to be irreversible, urgent, and so on and so forth, which even the standing committee has looked at it and said, the fundamental of mediation is a voluntary process.
Absolutely.
And therefore, you cannot, by virtue, impose on it, yet recognizing the fact that the parties may be referred to mediation by court and so on and so forth.
Right.
So if the parties contract for it, certainly. But of course, keeping in mind that you can parallelly, and which the mediation bill allows for it, parallelly seek urgent relief.
Right, right. And how effective is it?
So okay, let's take a statistic, right? So if you look at the Delhi High Court attached mediation center, Samadhan, that has in the last 5 years or so done all manners of cases. And if you look at a lot of the original site filing on the Delhi High Court is IP litigation. So about 14,000 odd cases were referred to mediation.
Right.
To Samadhan alone,
Right.
They refer it to the rest of the world as well, but to Samadhan alone, 14,000, and about close to about 8,000 cases were actually settled. And so that's an overwhelming majority. I mean, yes, the statistics would say that's nearly 50-50 or so, but not. But the fact is that those were settled. It reduced litigation cost. It reduced the burden. So even though the number may seem 50-50, 50 is a good number.
Very.
If you look at it in the overall scheme of things.
Right.
And it's mostly not very effective when lawyers themselves fight between themselves.
In fact, I'd like to add to the effectiveness part. See, there are 2-3 aspects to the effectiveness. One, lawyers' part is important because I feel as such for lawyers there is no incentive. What is the incentive for a lawyer there to have the matter settled? The other problematic and practical aspect is we do not have trained mediators. Just getting a training or a 40-hour training doesn't make you a good mediator.
I agree.
The approach is so different. The manner in which you have to conduct the mediation is so different. So I act as a mediator, I act as an arbitrator. But when I'm sitting as a mediator, my approach is very, very different.
Absolutely.
It has to be, and it comes with experience. So we are lacking that today. That is number one. That's a practical problem. The other aspect is all the other stakeholders involved and their approach as such to mediation. That is also very, very important. Because today what is happening is that lawyers just by choice do not attend mediation hearings unless of course they want the mediators to be asking them to please step out. So they choose not to attend, these hearings. That is number one. But the instructions to the parties is very clear. Aap sun ke aiye and, we'll deal with this. It's just a process we need to get over.
I agree. Yeah.
So that intention and the approach itself is not there.
Yeah.
If the and it's not their problem because, I'm sitting there as a mediator and these parties are coming to me for the first time, right? You have to develop that trust with the parties. It won't come on the first hearing. So that's why the training part is very important. How do you deal with the dispute at hand?
I agree. In
Can
fact,
I just add a third to what
yes,
I think that the important part is also to train the lawyers who are representing those
Absolutely.
parties, because I cannot
They
tell you
get
how many
very
mediations I
aggressive.
have been in as either acting as one or there where I'm addressed as my lord, and I'm like, when did I get elevated? You know? Because the mindset still is it's adversarial.
Of the court.
And
Yes,
that,
yes.
the fact that, and it is the mediator's job to make sure that it is conciliatory, and to put that forward. But when you have your trusted advisor sitting next to you and trying to make a point to the other side, that is not conducive to the whole concept of amicus.
For under the Arbitration Act, we had a conciliation, it's also Arbitration and Conciliation Act. I've acted as a conciliator in many proceedings, and it has failed miserably.
Fails. Yes, sir.
And that's one of the reasons, because it's like an adversarial process. Your lawyers are there, they're arguing it as if it's a court matter.
Absolutely. In fact, I myself have experienced that we have a dearth of trained mediators here. And while when we do mediation anywhere abroad, it's very different, and they are very professional, and they are going to, probably, I've done mediations outside where they actually settle the matter in one given day. Even if it takes 9 hours, 10 hours, they will finish it. They will not even let the parties meet each other, because they understand if the matters are of a sensitive nature, or if it can lead to an adversarial situation, then they will, probably work it around that way. So I understand. Ms. Bharti, coming to you, when we, of course, you discussed and you shared with us how ODR can be a very effective way of, or a game changer in the near future. What are the handicaps that are attached to it? Because
before coming to the handicap, Petal, I would want to add to the question that you have posed earlier in this regard. I think, and I am a very strong propagator of med as a concept, because once you have explored mediation and you have realized where do you stand, and if it is only the ego of the parties which is not letting them settle, then in that case you go back to arbitration.
Right.
And the arbitrator thereafter adjudicates on the issue, and you sense of, you are able to then gauge on where you stand legally as well. And then when you come back to mediation, I think it really works well. So if we are talking about, high value disputes, I think med is definitely going to have a future ahead of us. So, and making it mandatory in that sense, I don't think that any law can make arbitration or mediation to be mandatory, because this is something which is because of the choice of the parties. So both, the dispute resolution concepts have its own limitation in that sense, that it cannot be made mandatory by the legislature. So unlike the Commercial Courts Act, where it can be, because there are certain kinds of disputes which are taken before the commercial courts, here in the arbitration sphere, it is more about the party's choice and willingness, and that is how you decide on the venue, seat, everything is because of the choice of the parties. Right. So that is how it has to be. So we as lawyers have to be sensitive that to understand whether it can be, or the disputes can be resolved between the parties through mediation. We have recently, in fact, in one of the arbitration matters, and it was the arbitrator who actually pushed the parties to try and settle, because he said, see, these are the loopholes in your case, these are the loopholes in the counterclaim. Now you decide whether you want to go ahead or not. I have not made up my mind, but I can tell you what the loopholes in both the cases are, because you have reached the evidence stage. Right. And at that stage, when the parties realize that it is possible that we may or may not get what we are actually fighting for. So it was the time when we really were able to push the clients, and the clients were able to settle the matter. So those success stories are also there when we talk about mediation.
I think in that lawyers also play a very important role.
Very important role, absolutely.
Very important role, and what she pointed out is really very important issue. Meltdown of ego.
Absolutely.
When does the dispute happen?
When they know that there there are certain loopholes in their matter, is when the meltdown of the ego also happens.
It is one of the most important ingredient of the recipe of dispute.
Absolutely.
Clash of egos. So when you talk to each other, those egos come down. Many a times they come down. If that doesn't come out in one go, it will come down in the second go. Right. Sometimes it happens twice, thrice. People have gone to mediation. Absolutely. On fourth time, they have ultimately resolved the matter. Yes. Recently, that has happened to me.
Yes, same here. Yes, absolutely. Yes.
Yeah, so coming back to the question that you had asked, I think we addressed it in the first round itself in terms of the challenges. Of course, the digital literacy is one very important factor, because I think 70% of our population still needs to understand what ODR as a concept is. There are very few people who understand it. So unless and until we have a sense of digital literacy, people will not be able to take it up as a process. Second, of course, is the lack of awareness, as we mentioned. I think it is important to talk about in these forums on the virtues of ODR and why and how it should be attached to the consumer courts to reduce their burden, and also with the other metropolitan magistrates, etc., to be able to reduce their burden respectively. And third, very important, is the digital infrastructure, which the government is already creating in that sense, but there is still a lot which is required to be done. The penetration of the internet to the rural villages is something which is necessary for us to develop ODR as a concept. So I think till the time all of this is not done, we still are a little behind in that sense in terms of implementation of ODR. But with the legislature, the judiciary, and the executive all thinking in one direction so far as the implementation of ODR is concerned, with Niti Aayog coming up with its report also. And then if you look at the RBI also, which has focused on all the disputes relating to digital payment systems to be only resolved through the online dispute resolution forum. SEBI also coming up with this platform called SCORE for the resolution of the disputes.
Yes.
I think there is a lot of work which has already been done. So it is now about just seeing the dream to be a reality in some time that we are seeing it.
Mr. Sen,
I'll just add to what ma'am mentioned. You see, I think the problem is a little more basic. The first thing, as she mentioned, the access to technology, but access to technology also has very many dimensions. One is, as basic as having a steady internet connection. When you're having these hearings, as such, the problem is that, you're dealing with someone who has a bad network. These are practical issues, right? The other is the comfort part of the parties to deal with technology, and I'm talking of bulky matters, voluminous matters, where, either your filings are that efficient that, if a lawyer is referring to a particular document, he's able to, the arbitrator or the mediator, whatever, I mean, arbitrator more so, is able to, get to that document very quickly. Otherwise, it can be a very frustrating exercise. Add to that, I also feel there's a little disadvantage, especially with respect to mediation, because mediation, I feel, requires that personal touch. Which will come in only when, I feel you're sitting down with the person, you're trying to understand that person's body language, I'll share an example. In fact, I was acting as a mediator in this matter, and this lady, and I refer to this a lot, we were struggling with both the parties. It was a simple property matter where, they were all in agreement that this property needs to be partitioned. Like, only one had to understand what floor will go to which brother. But this particular lady, who was a widow, she was not agreeing to any solution which was being offered by the brothers concerned, right? And we as mediators were watching, and at the end of it, my co-mediator, we were like, then we might as well send the matter back to the court. To that, the lady immediately said, no, I need one more hearing. You don't send the matter to court. So we adjourned the matter that we'll take it up the next time. Now, when the other brothers left, this lady walks up to us and tells us, I am going to settle this matter, but I'm going to push them, I'm going to frustrate them, because when my husband passed on, they really created a ruckus in my life. They were not supportive. So now is my time. The point that I'm trying to make is these are things which may not come out in an online platform. The problem may be, the cause for the dispute may lie somewhere else, right? But you may not be able to appreciate or understand that. Right. That may just come out only through a physical platform.
Absolutely. Yeah. Mr. Sen, when we talk about, of course we know now with the judgment that the stamping of arbitration contract is mandatory, and only then it is enforceable. Of course, it has been interpreted also in various ways. We have seen somewhere that a lot of times corporates also have very basic contracts, like you mentioned, ideally any arbitration should only be in a contract which has a value more than 10 CR. But how it has been happening is that in most of the contract, actually all of the contracts, even employee contracts, one wants to include arbitration because it's a more controlled proceeding in some way, and the corporates think like that. Now, when we think of that, and when we think of the procedure that we need to follow of stamping those contracts, of course, it looks like an impediment in, ease of doing business. What is your take on that?
Well, it's possible, of course, as we all know, that the judgment has come under severe criticism, and there could be a relook. The Supreme Court could have a relook at the judgment, but as it stands, that is the law. So I don't think, as far as that is concerned, we will have any option or choice. We'll have to go ahead with it. One very important function and benefit of arbitration, and to some extent mediation also, is confidentiality. We shouldn't lose sight of that. So that's one thing which a court litigation will simply not be able to provide, because by definition it's a public proceeding. Whereas in arbitration, it really helps. In fact, the other day in our firm, there was a discussion as to, in our engagement letters, what should we have as a dispute resolution clause? All of lawyers, we have engagement letters. Should it be a simple dispute resolution, or should we have arbitration? There was a lot of internal debate as to what it is. And my take on that was that don't forget, confidentiality is something important. So if you have a rogue client and there is a lot of fees pending and you want to go after that fellow, then it's something which you don't want to go for the court.
Absolutely.
It's something which you want to do it in private.
Yeah, like you want to keep it restrictive and controlled.
Yeah,
maybe.
for the record, we have not done any of that, but...
Mr. Malik, yes, you want to?
One can provide for a provision of expedited or fast-track arbitration.
Yes.
So now with this new amendment, one can actually finish arbitration within 6 months. One can say that there will be no evidence will be led,
Yes.
no hearing will be given.
Yes.
Only
In smaller contracts,
Yes.
that can be done.
So you only
Yes.
say that you file your pleadings, no hearing, and there will be a award. That's
Right.
it.
Right.
it
Mr.
helps.
Malik, yes, in foreign contracts, if you can elaborate on this, that how much, of course, we did discuss that how seat and venue can be very, very important when we are actually, drafting the clause. Especially in foreign contracts, when there are foreign parties involved, what is your take in that? How important it is to, specify the seat and the venue, or let's say the place, very, very categorically, and how much importance that
It is extremely
plays?
important, and once you suppose there is an Indian party and there is a foreign party, you are entering into an agreement, and then you want to arbitrate, then it is very important to understand that the emergency awards, so-called emergency awards under CAC rules, if they are passed, there is no mechanism to enforce them here in India. So
Right.
you only remedy that is available to you in that case would be you file a Section 9, and courts have held that in those cases you can file a Section 9.
Right.
That continues to apply after the amendment that eased off that problem.
Right.
But earlier there was no such mechanism.
Right.
So it is very important. In fact, interestingly, the Supreme Court has recently given that judgment where even Indian parties can choose foreign seated for arbitrations.
Right.
So where, for example, the disputes are huge, and the confidence in their system is more as compared to ours because of the vagaries that we
Yes.
face. People are choosing that. It's a recent trend.
Yes. Yes.
Now Indian parties are choosing foreign seated arbitrations.
Absolutely.
That is
Absolutely.
happening.
So, coming to Mr. Chandhiok, and I think we'll close with this. When we talk about seat, and when we talk about, let's say, a foreign party and an Indian party, a lot of times the Indian party feels like how Mr. Malik also rightly said, that having a foreign seat is much more beneficial, and maybe a jurisdiction of that effect too, because then it's easier to enforce it in their jurisdiction when it comes to executing the orders or awards. What is your take on this? Should we do it? Should we not? How to go about this?
I think the first point is it comes down to how parties, typically parties will look to a neutral venue or a place, and that's where certain centers have come up across the world, and that is attractive to all parties, especially with sort of if you look at the fact that the New York Convention has allowed for whether you're an Indian party or a foreign party, doesn't matter. If you have an international award, you can enforce, and that is the benefit that gives you. And that has value across the board, across nationalities, across jurisdictions. That if you distinct that from, for example, the mediation, the current draft of the mediation bill does not give it that same parity. And therefore it doesn't enforce the Singapore Convention in its full form. So there are, again, goes back to what we were discussing earlier, intentionally drafting your arbitration clause, what matters to you, where it matters to you, would mediation work, would arbitration work, would med work. All those things are considerations that one will, it's very difficult to anticipate, especially in the euphoria of doing a transaction, but at the same time, it is important to take a step back and see what works.
Right, right. So thank you so much to all the panelists, and thank you for the audience to really being very patient with all of us. Thank you.